Good evening, viewers, and thank you for joining in this session on free trade agreements. And today we are really going to go through a very detailed phase because we understand what free trade agreements really mean for the country, and especially in terms of trade. So I would like to thank, first of all, SOCA, that's the Society of Crop Business Advisors of Kenya, for organizing this webinar. Without them, this would not be possible. And also the team that works behind the scenes, that's Lillian Wanjiro, Winnie, as well as Angela Limo and the SOCA team in general that works behind the scenes to ensure that this takes place. And today we have 3 guests with us. And as we introduce them, we are going to get to know what they do, and especially their role when it comes to the free trade agreements. So we'll have an introduction from Brian. That's the one who will start today. And just Brian will give a brief overview of what the free trade agreements, the ratification, and what that means for Kenya in terms of trade, and in terms of what has been done over the years in terms of the engagement with the free trade agreement. Apologies, let me just get his profile. Just give me a minute. So Brian is a commercial lawyer, and he has deep interest in corporate and intellectual property law, conveyancing, international trade law, and banking and securities as well. His clients find him resourceful, and especially when it comes to getting into the practical solutions. And his growth as a lawyer at a personal and organization level has really impacted in terms of his career. He has worked for L.W. Wangombe and Company Advocates, and he has trained in terms of legal practice in the field of insurance claims, litigation, conveyancing, banking and securities, debt collection, as well as intellectual property law. So welcome, Brian, Dennis, sorry. And we are going to learn more about what you're going to tell us about, take us through in terms of in terms of the free trade agreements. Yeah, welcome, Dennis. Winnie, could you please project?
Thank you very much. Thank you very much, Nakesa. I am Dennis Dirango. I'm not Brian, which is okay. So,
yeah, apologies for that, Dennis, sorry.
It's okay. I want to appreciate SOCA and especially Lydia for allowing me to present on the treaty ratification process in Kenya. But before we commence, I would like to appreciate what SOCA is doing to the society in terms of ensuring that the economic and social rights are achieved. If you can refer to the Constitution, Article 43, 1C says that every person has the right to be free from hunger and to have adequate food of acceptable quality. That is enshrined in our Kenyan Constitution, and I appreciate that SOCA is driving that agenda to ensure that that is achieved. Most people do not know that you have a right to be free from hunger in our Kenyan economy. It is actually a right, and you can sue to ensure that government achieves that right. So I will be very brief. I will not, ratification is a very detailed legal process, but I will just go straight to the point. So ratification is one section of a treaty making process. So a treaty is made and it is signed between parties, but ratification comes in when both parties consent, they accept to the terms and conditions outlined in that agreement. There is the approval process, assertion of the treaty. So ratification is a very important process in ensuring that any convention or treaty that is signed between countries is approved. Countries can sign a treaty, but without the ratification process, it cannot be acceptable. I will be very simple in my legal language so that we get to understand. So what are some of the laws I will be looking at to ensure that we understand the ratification process? We will start off with the Constitution of Kenya. The Constitution of Kenya is a supreme law of this land, and it is important to know that Article 2(6) of the Constitution gives any treaty or convention ratified, the word ratified by Kenya shall form part of the Kenyan laws. So any treaties that have been signed before, like the Convention Against Torture, the Convention for Humanitarian Aid, the Convention on Human Rights, if it is ratified, it forms part of the Kenyan law. So the Constitution accommodates any treaty ratified to form and be part of the Kenyan law. Let's narrow down to what the Kenyan jurisdiction specifically uses to ensure that the ratification process, the legal framework of ratification is made efficient and it can operate. So we have an act of parliament by the name, the Treaty Making and Ratification Act number 45 of 2012. So this is an act that I'll be jumping right into with regards to the making process. And this is the act that I would want us to focus on, specifically on what is the process of ratification. It is also important to know that the act does establish a registrar of treaties, which would mean that for every ratified treaty, not for every signed, remember the word, for every ratified treaty is entered into a registrar, into a register, and it is recorded as a ratified treaty. Now, let me discuss a little bit about the agreement establishing the Africa Continental Free Trade Area Agreement. This is an example of an act of a treaty that I will be looking at, and also the Kenya-UK Trade Deal Agreement. So we can proceed to the process, the process of ratification. So I'll be very straight to the point on the ratification process, whereby the process will start by the Cabinet Secretary in charge of that particular treaty. It can be the Cabinet Secretary of Foreign Affairs, or the Cabinet Secretary for Trade and Investment, or the Cabinet Secretary that enables that treaty to work in consultation with the Attorney General. So the Cabinet Secretary and the AG, let's give it an example. The UK and Kenya Trade Agreement, or the AFTA agreement. So the CS for Foreign Affairs came together with the AG, and they formed a memorandum outlining what is exactly in that treaty that is being proposed to us. So this is a discussion that happens at a cabinet level. And the memorandum will outline the objects and subjects of the treaty. So for example, it is a trade treaty, it is a dispute settlement treaty, it is the AFTA agreement with regards to ease of doing trade within Africa. So it will outline that. It will also outline the constitutional implications of the treaty. Does it affect the supreme law of our land? Does it go against the Constitution of Kenya? So that in case it is ratified, it does not become unconstitutional or go against the supreme law of the land. The question that Cabinet will also ask itself is the national interests which may be affected by the ratification of the treaty. What are some of the interests that will it have an economic, financial, security impact? Will it have a diplomacy impact? So these are some of the questions Cabinet will discuss to ensure that the national interests are covered. The memorandum will also contain the obligations imposed on Kenya by the people or the relevant country that has drafted the treaty. What are some of the obligations? The obligations, I would not like to go into details because of limitation of time. What are some of the requirements? Another important agenda that Cabinet will also consider before they forward this treaty, the ratification process, is a policy and the legislative consideration. What are some of the policy issues? What are some of the policy items that will need to be drafted? What is the legislative agenda? Does it affect any legal framework? So these are some of the questions they will ask themselves when considering the memorandum. Another important consideration, which will involve the Cabinet Secretary of Treasury, is the financial implication of the treaty. They do not just ratify. What are the financial obligations? What are the budget constraints? What are some of the financial or economic issues or questions that will need to be addressed when signing the treaty or ratifying it? Another item that will be considered is a ministerial responsibility. Which ministry will be in charge of ratifying or enforcing this treaty? Is it the Ministry of Trade, the Ministry of Transport? Is it the Ministry of Health? So it will entirely depend on what the treaty is all about. Just to quickly go through the summary of the process to the adoption of the treaty, the date of the signature. Now, this is very important. The date of the signature, in simple terms, would be when we are watching news and there is a report that both parties, Kenya and the UK, or Kenya and Nigeria, or Kenya and China, have signed a treaty. The date of the signature. Another important element that Cabinet will consider is the number of states that are party to the treaty. Now, not accurately mentioning, the AFTA is affecting all the 55 countries in Africa, and probably half or 3/4 of the countries have ratified, meaning that there is a lot of unanimity, there is a lot of unison in terms of the agreement. Now, the UK and the Kenya trade agreement is just between two countries. So that is a treaty that affects Kenya and the UK, basically. So there are various types of treaties. Another important element is the views of the public on the ratification of the treaty. What has the general public think? What is the public participation process? Another item is whether the treaty sought to be ratified permits the reservation of any recommendations on reservations and recommendations, whether the expenditure of public funds will be incurred in implementing the treaty. So these are some of the things that Cabinet will tend to discuss before that memorandum is approved. And that process is very crucial. So Cabinet will endorse it and forward it to Parliament for approval. So the step that I have been talking about is under Section 7 of the Treaty Making and Ratification Act, the approval by Cabinet. So once that is approved by Cabinet, the treaty is forwarded to Parliament. If you can take me to the next slide. The National Assembly is empowered by the Act to ensure that there is consideration on the nature of the treaty. So the Cabinet Secretary, upon receiving approval from Cabinet, will forward the memorandum on the treaty to the Speaker of the National Assembly. In this case, Honorable Muturi will receive now the memorandum of the treaty. So the treaty approved for ratification by the Cabinet will depend on which relevant house. So the National Assembly or the Senate. So most of the time, it's usually the National Assembly that will look into the ratification process. And another committee in the process, inside Parliament, the relevant parliamentary committee will need to be involved. For example, in the UK trade deal agreement, the Trade and Investment Committee will have to be involved when initiating the process of ratification in Parliament, because they are the ones who will prepare an order paper which will be presented before the members of the National Assembly. So a sessional paper will outline the memorandum that was approved in Cabinet, the details of the treaty, so that public participation is ensured in the ratification process. Parliament can approve without any amendment, and Parliament can approve and can amend and approve, and Parliament also has the power to reject the treaty. A proposed reservation shall be introduced as a provision into the treaty in accordance with the procedure set out in the standing orders. So a reservation would mean that who is the member of Parliament, or who is a member who is not in agreement with the treaty, would they like to amend? And for your information, this is a current stalemate that is currently happening in Parliament. The UK trade deal agreement that was recently signed and has not yet been ratified is that it limits parties from not amending the treaty. And the Parliament in Kenya has been given powers to amend. But in this instant, it's one-sided, such that the UK, through the council, through the Economic Council in the UK, is the one that gives a nod on the approval, but that is not the process in the Kenyan system. So that's why there's a gridlock between the ratification process. So the approval process happens, both houses. If both houses refuse to approve the ratification of the treaty, the speakers of the two houses, so this is the Senate and the National Assembly, shall submit their decision to the relevant CS. In this case, the CS for trade and investment, or the CS for health, or the CS for the relevant body, within 14 days of the decision. It does not end there if both parties reject. So there is the option of resubmission of the memoranda by the CS, where the approval for the ratification of the treaty has been refused. So it is important to note that Parliament shall not approve the ratification of a treaty or part of it if its provisions are contrary to the Constitution, which is the supreme law, nor shall the House approve a reservation to a treaty or part of it that the reservation negates the supremacy of the Constitution. So in this instant, there is an option to approve as it is, or amend and have discussions between parties so that the process can continue. So I don't want to go into details on what needs to be done, but I would like to go to the next stage of the approval for ratification. Now Parliament has approved the treaty. So what is basically on the procedure for the approval for ratification? I had not mentioned everything in the slide, despite the short notice, but the approval process is where the relevant CS, after the approval by Parliament, after 30 days, will prepare the necessary instruments for ratification. So what are these instruments? The instruments would include a signature, a seal, or an approval from Parliament. And once this is approved, the treaty is entered into the registrar of treaties, and it is deemed to be part of the Kenyan law. And the treaty is ratified, and it is deemed to be part of the Kenyan law. So it becomes operational. So that is basically the process on an overview, but there's so much more with regards to international law that I have not touched upon. So I was requested to focus on the Kenya-UK trade agreement, and I have put a few comments on that slide. MPs have taken issue on the clause with regards to the amending of the treaty. So the reason why there is no progress is because the element of amending the trade deal is not accommodated in the treaty. Item number 2, the members of the National Assembly have said that it violates the provisions of the treaty-making process, which I just outlined. The local law, which is the Treaty Making and Ratification Act of 2012, gives the National Assembly the power to amend. But in this instant, the treaty does tie their hands. There is no element of amending, so that's why there's a gridlock. A review of the EPA protocols, which have over the years guided trade between Kenya and the UK, as well as the EU nations, show that Parliament does not have powers to introduce changes to the trade deal at the ratification stage. So at a supreme level, at the council level in the UK, the EPA Council, the European Council on the issue of trade, does issue a clause that this cannot be amended as it is, and it should be passed without reservations. Let's just proceed quickly. The options available to the parties, if they do not agree, is that parties may agree in writing to amend this agreement. So the UK Council on Trade and the committee or the relevant body in Kenya can sit down and exercise the element of mediation and identify parts that they do not agree upon, such that when the cabinet secretary is reintroducing the agreement into Parliament, there is a harmony, parties have agreed, there is an enabled item of reconciliation between the parties. So basically, that is what is exactly happening. On another level, which I did not mention in the presentation, is the Africa Continental Free Trade Area Agreement. It's a treaty that has already been ratified in the Kenyan legal system. And why was it so easy for it to pass through? Is because there was a common ground. There was a common element of ensuring that there is ease of trade between countries, between the different economies, between the different blocks in the African continent. There was no hitch, and there was acrimony, there was harmony when the trade agreement was signed in Kigali some time back. So the element of signature happened, but countries were left to ratify. Now, different countries have a different ratification process, but basically in Kenya, that is basically the process. Now, there's some legal jurisprudence brewing in court, whereby the Kenya Small Farmers Forum has sued or has petitioned EPA to ensure to summon and say that the agreement is in utter violation of the fundamental rights and freedoms of the Small-Scale Farmers Forum. So it's a case that is still alive in court. I do not have, I can't comment much. But basically, if you remember on what I started on, is the element that every citizen has a right to be free from hunger. So if a particular region in the Kenyan economy is suffering from famine or hunger, the government has a right to ensure that the enforcement of economic rights in terms of food and availability of quality food is given to them. As I approach, we will have a Q&A session, but I would like to end my presentation by a quote from the Africa Development Bank President, Adenisa, who is currently Nigerian. He outlined that agriculture cannot afford to remain an old tradition, subsistent activity. It must become the next big thing, investment magnet, a package of bankable projects that will turn some of our youthful population into millionaires through innovation and enterprise. So I appreciate the team, SOCA, for helping me present on this item of the ratification process. And back to you, Nekesa. Thank you.
Thank you so much, Dennis. At least I've gotten your name right this time. Finally. And I look forward to the number of questions that have popped up, especially in your presentation. It's quite interesting what you presented, and I'm sure quite a number of us are not even aware of the process and what actually takes place behind the scenes before a treaty is signed between different countries, or even a dual or even the multiple kind of treaties. So we are going to have Sonia as our next presenter. Sonia Red Smith has a BSc honors in law. She's also got an MA from the University of Oxford and is currently a legal advisor and senior researcher with the Third World Network, that's TWN. She analyzes the implications of international trade and investment agreements on law and policies, including environmental regulations in developing countries. Recent negotiations that Sonia has been included in terms of analyzing include the US-Mexico-Canada agreement, the European Free Trade Association, FTA, with developing countries, the WTO negotiations. She has given presentations on these issues at conferences organized by the UN, Economic Commission of Africa, Commonwealth Secretariat, among others. So we look forward to your presentation, and welcome, Sonia.
Thank you very much, and thank you for kindly inviting me to join this webinar. So I'm not an expert in Kenyan agriculture, but I thought that the experiences of some other developing countries negotiating free trade agreements, like with the US, the way that Kenya has been, may be relevant. And I take the Kenya-US free trade agreement as a case study because that's one that's still under negotiation, so not yet at the ratification stage, whereas the free trade agreements with the UK, as you heard, and the CFTA are already complete. So in this webinar, we will focus on the impacts on Kenyan small farmers, but of course, say the Kenya-US Free Trade Agreement, for example, can affect Kenyan agricultural policies more broadly, value addition of Kenyan agricultural products, manufacturing and other sectors, health, including pandemic measures, and the ability to recover from the pandemic and its economic crises. So on the next slide, of course, in Kenya, I understand the starting point is the African Growth and Opportunity Act, which I understand is important for Kenya's exports. That is scheduled to expire in September 2025. And of course, under AGOA, many of Kenya's exports already enter the US with zero tariffs. But AGOA is regularly renewed, and you can see there that it has been renewed quite easily in the past, regardless of which party is in power in the US, and it's a decision of the US Congress, and it's been popular with the US Congress in the past, so people generally expect it to be renewed again. So the question then is, if AGOA is the baseline and that allows most Kenyan exports to already go to the US with zero tariffs, what are the additional benefits that Kenya could get from a reciprocal US free trade agreement in terms of new market access, and what would Kenya have to agree to in order to get that? So on the next slide, as you know, the US heavily subsidizes a lot of its agricultural products, and it might be a bit faint, but basically anything below the line is exporting from the US below the cost of production. Their subsidies are so much. So you can see that, above the line is exporting below the cost of production. So you can see that wheat, which is the line in maroon color, is nearly always exported from the US below the cost of production because it's above the line. On the next slide, you'll see that for sorghum, for example, it was exported from the US below the cost of production every year from 2005 to 2016, except in 2007 and 2010. So you can see, for example, in 2005, sorghum was exported from the US at 45% below the cost of production. So this is the underlying kind of environment that a Kenya-US FTA would come into. So on the next slide, you'll see the range of chapters that might come up in a Kenya-US free trade agreement. This is from the US-Mexico-Canada agreement, which was the recent US free trade agreement completed under the Trump administration and is a kind of standard US free trade agreement. And you can see from the structure here that about 9 of the chapters are what you would think about as trade in goods, about removing tariffs on Kenyan exports of tea and coffee, the sanitary and phytosanitary standards, and so on. And the other 26 chapters are about other domestic policy laws and regulations in Kenya, some of which could affect agriculture, as we'll see later. So on the next slide, we start with the goods chapter. So as we just looked at, you can see that the US has large agricultural subsidies. The US domestic subsidies per farmer is almost $69,000 per year. And the question is whether a US free trade agreement would restrict the amounts of subsidies that the US can give their farmers. And the answer is it probably won't, because you can see in the USMCA, the only restrictions on agricultural subsidies were to ban export subsidies, which has already been agreed at the World Trade Organization. So that domestic support of almost $69,000 per farmer per year in the US is not touched. That can still continue under US free trade agreements like the USMCA, which may well be the model for the Kenya-US free trade agreement. And you can see historically the US has refused to cut its agriculture subsidies in free trade agreements, including free trade agreement of all of North, Central, and South America, except Cuba, because they said that subsidies can only be disciplined at the World Trade Organization. So the US is likely to keep its subsidies in any Kenya-US free trade agreement, but the US is likely to ask Kenya to remove its tariffs, its taxes on imported US farm products coming into Kenya while they are still subsidized. So sorghum subsidized 45% below the cost of production, and then the US asks for Kenya to remove tariffs on that subsidized sorghum or wheat or dairy and so on. And in past US free trade agreements, the US has required the removal of tariffs on 97 to 100% of US products. That was, for example, in the Trans-Pacific Partnership Agreement. And you can see there that Kenya still has quite high tariffs on imports of certain farm products, including milk, corn, rice, wheat. And there was a study that found that if you go down to a 10% tariff on wheat, then it would be cheaper than Kenyan wheat. But the US is likely to ask Kenya to remove its tariffs on wheat down to 0% and remove Kenya's 100% tariff on sugar and so on, while the US keeps their subsidies on their wheat and sorghum and sugar and dairy and so on. Of course, Kenya can also do agricultural subsidies, but the question is whether the Kenyan government has the budget to provide subsidies the size of the US, which is $69,000 per farmer per year. So on the next slide, this is some examples of what's happened when other countries have had to remove tariffs on subsidized US farm products coming in. This was Mexico's experience under the original North American Free Trade Agreement between Mexico, US, and Canada. The US exports of cheap corn to Mexico increased by more than 400%. Almost 5 million Mexican family farmers were displaced. Wheat cultivation halved. 99% of their soybeans became imported. So Mexico did manage to export a bit more fruit and vegetables from the large farmers, but this was outweighed by the huge increase in imports of subsidized US staples like corn and so on. Then Ghana, for example, has had experience trying to compete with subsidized chicken imports. You can see that in 1992, domestic chicken farmers supplied 95% of Ghana's market, but by 2001, they only supplied 11%. And this was because of the cheap subsidized imported chicken coming in. And they tried to increase their tariffs to 45%, but they couldn't, or they wouldn't get loans from the International Monetary Fund. And the chicken farmers estimated they would need tariffs of 80% to compete with the subsidized chicken imports, including chicken parts that are not, commonly eaten in developed countries, like chicken wings and chicken necks and so on, which are sold at much less than the local cost of production. So because of this competition from subsidized imports, you can see the utilization rates of Ghana's hatcheries, feed mills and processing plants was, less than 50%, and the job impacts this had, including for maize growers for feed for the chicken industry. On the next slide, of course, if you remove tariffs on imports, this can also have an impact on government revenue, depending on how much the Kenyan government depends on tariffs as a source of taxation revenue. And then the question is, if you lose that tariff revenue because you have to remove all your tariffs on US products coming into Kenya, can you make that back from other taxes like a value-added tax? And you can see there the International Monetary Fund study that found that for a middle-income country like Kenya, at best you make back 45 to 60% of that lost tariff revenue. And I understand that because of the COVID-19 pandemic, Kenya has had some pressures on its budget and has already needed loans and so on because of its lack of revenue. So the question is whether further losses of tariff revenue due to a free trade agreement would be suitable for Kenya at this time. And then, of course, there's also the question about the impact of a reciprocal US free trade agreement on Kenya's goods trade balance, because as we know, most of Kenya's exports already enter the US with zero tariffs under AGOA. And you may get a few extra exports, say of tea or coffee or something that's not currently zero tariffs under AGOA. But in return, if Kenya has to remove tariffs on all US products coming into Kenya, then it's likely that the imports into Kenya will increase by more than Kenya can get extra exports. So then Kenya is likely to see a worsening of the goods trade balance under a US free trade agreement. On the next slide, the trade facilitation provisions in the Kenya-US FTA. This is about things coming across the border quickly through customs, but the US may also make proposals about de minimis. And the de minimis level says below this amount, it's such a small amount, it can come in tariff-free. And I'm unclear, but I think Kenya's de minimis at the moment may be $0. So even $1 of wheat coming into Kenya has to pay whatever the wheat tariff is. Was it 60%? But in the Kenya-US FTA, the US objectives, which are public, asked for a de minimis level like the US's. And the US level is $800. So even if Kenya managed to keep tariffs on, say, US wheat, every shipment that is less than $800 still comes in with zero tariffs on wheat. So that much wheat or milk powder and so on could still come in tariff-free into Kenya if the de minimis is $800, even if Kenya manages to keep tariffs on wheat or powdered milk in the US free trade agreement. On the next slide, I just had a quick look at the sanitary and phytosanitary measures chapter. So this is, quarantine against mad cow disease or foot and mouth disease or other animal and plant diseases. And the US government has an annual report where they look at practices they don't like around the world by other governments. And they note that Kenya's letter of no objection system by the Department of Veterinary Services for meat and dairy and poultry it's never given the rationale for it, and it may not be for sanitary reasons. So on the next slide, you'll see that this kind of Kenyan law may be in trouble if the Kenya-US Free Trade Agreement has provisions like the USMCA's SPS chapter, which says that if you have this kind of certification requirement, assuming that's a certification requirement, it has to be based on international standards or about human, animal, plant life or health, not other reasons. So it's not clear to me whether Kenya could keep this no objection letter system if it agreed to these kinds of rules in its US Free Trade Agreement. And of course, the US Free Trade Agreement, I should have said, was being negotiated under the Trump administration. And now that the Biden administration has taken office in the US, they have said they're going to review it. So we're not sure if those negotiations will restart, and if they do, whether they'll continue on the same template and objectives as the Trump administration established. But President Biden, when he was vice president in the Obama administration, very much that administration had the kind of full template US Free Trade Agreement like the USMCA. So if he reverts back to what he did in the Obama administration, it would be a kind of 31 chapter free trade agreement like the USMCA anyway. Okay, on the next chapter, sorry, we're going a bit fast, but this is a many thousand-page free trade agreement, but I'm trying to squash in its implications for agriculture in the limited time. So government procurement is where the Kenyan government, for example, the Ministry of Defence buys food to supply the Kenyan soldiers. Do they buy that food from Kenyan farmers, or do they buy it using imported wheat or imported rice? So there are some Kenyan policies and laws here, the Buy Kenyan, Build Kenya, and the Public Procurement and Asset Disposal Act, which say that if the Kenyan government is buying stuff that is less than 50 million Kenyan shillings, it shall buy from Kenyans. So from Kenyan companies and Kenyan products and Kenyan farmers. So that's the situation today. That procurement is set aside to help Kenyan farmers or Kenyan manufacturers and so on. On the next slide, we'll see that in the US Free Trade Agreement, the US has said that they want non-discrimination in this government procurement. So US wheat is treated the same as Kenyan wheat in terms of who gets to supply the Ministry of Defence. And remember that the US wheat may still be would still be subsidised and may come into Kenya at zero tariff, so may be cheaper than the Kenyan wheat. And then the Kenyan Ministry of Defence has to buy whichever is the cheapest wheat flour to supply the Kenyan soldiers. So here they do it, you liberalize, you open to US companies and products like agricultural products for the ministries listed, and that's negotiated. So for example, Malaysia had to list all of its national ministries, even though it probably didn't want to liberalize them, for the goods and services that are liberalized. And here Malaysia, for example, liberalized all goods except those listed. Like it was everything except, I think, rice, soup, sauce, and something else. And for those products that are above the threshold, and you can see there in the USMCA, it was about $80,000, then you cannot set aside those contracts for Kenyan farmers. You can't give preferences to Kenyan farmers. You have to buy whichever is cheaper, the Kenyan wheat or the US wheat. And the US wheat is still subsidized and may come in with zero tariffs. So that means that the procurement today between $80,000 and $487,000, which today is given to Kenyan farmers and Kenyan manufacturers, would be opened to US farmers and US manufacturers. And if theirs is cheaper because it's subsidized and has zero tariffs, then the Kenyan government would buy from US farmers instead of Kenyan farmers. And the same for if Kenya has any state-owned enterprises like Kenyan Airlines. Do they buy the food to supply the passengers from Kenyan farmers? If they do, in the USMCA, that would also be liberalized. So for all contracts, even the $1 contract, for all state-owned enterprises except those listed, you have to buy, the state-owned enterprise like Kenyan Airlines has to buy the cheapest wheat or rice, whether that's Kenyan or American. The next slide is the investment chapter. Sorry, I'm conscious of the time. So this is just to briefly mention that, of course, in Kenya at the moment, foreigners cannot own land, but the Kenya-US FTA, based on the US objectives, is likely to include national treatment, which means that Americans have to be able to own land the same as Kenyans, except in sectors where Kenya gets an exception, and you have to negotiate that list of non-conforming measures. There are some other provisions which we don't really have time to go through. Moving on to the services chapter on the next slide, I just wanted to note that access for small Kenyan farmers to banking services may be reduced under the financial services liberalization that the US seems to want in the Kenya-US FTA, because when foreign banks come in, they often just cream skim and they just do the profitable banking in the big cities for the big companies. They don't want to have to open branches in every village, which is, it's expensive for small loans and so on. And so then to compete with them, the Kenyan banks also close their branches in villages and so on. And so what ends up is you can end up with less loans to small farmers and small and medium enterprises once you liberalize banking. The next slide. This is the digital trade and e-commerce chapter. So if, for example, Kenyans want to repair their own tractors or have Kenyan mechanics repair them instead of taking them back to John Deere, you will need to access the source code, the software, and the digital trade or e-commerce chapter can prevent local repairers and farmers from being able to access that. So you have to take it back to the original equipment manufacturer. Because Kenyan farmers and mechanics wouldn't be able to access that software to fix their own tractors. Then we come to the exceptions on the next slide. So there is an exceptions chapter in US free trade agreements like the USMCA. It has an exception for health and the environment. It's very difficult to use. It doesn't apply to chapters like the investment chapter or the intellectual property chapter. And there's no exception for farmers' rights, for example. There is also an exception for tax, security, and balance of payments. On the next slide, so how is all of this enforced? Usually in a US free trade agreement like the USMCA, governments can sue each other if they don't comply with these rules at an international tribunal. And then if the Kenyan government loses, the US can raise the tariffs on Kenya's exports, say of tea or coffee or vegetables, until Kenya changes its law to comply. So this is very enforceable. Now, of course, Kenya can do the same thing if the US doesn't comply. But in practice, because Kenya is more dependent on the US market than vice versa, Kenya may not be able to effectively enforce against the US. This is because 0.02% of US exports to the whole world went to Kenya. So if the US doesn't comply, for example, they don't remove tariffs on Kenyan tea the way they're supposed to in the US free trade agreement, and Kenya says, right, they sue the US, they win, they raise the tariffs 1,000% on US cheese. US cheese exporters aren't really going to feel it because only 0.02% of their exports on average go to Kenya, whereas 11% of Kenya's exports go to the US. So if Kenya doesn't comply by, say, removing tariffs on wheat or milk or sorghum as required by the US FTA, and US sues Kenya and Kenya loses, and the US raises the tariff on Kenyan tea or coffee or clothing, Kenya is likely to feel it since on average 11% of Kenya's exports go to the US. So Kenya will is likely to feel forced to change its law to comply with the US FTA. So lastly, is there some special and differential treatment in US free trade agreements? And this just shows you that in fact the US gives itself special and differential treatment where it does less. So you can see the US, for example, here liberalized 99%, whereas other countries like Chile and Peru, developing countries, had to liberalize 100%, so they had to do more liberalization than the US. The US got the longest transition period, 30 years before they removed tariffs on cars, whereas Vietnam, the poorest country in the TPP, the longest transition period they got was 12 years on intellectual property on medicines. So the US, for example, exempted itself from having to allow foreign workers in the US free trade agreement, the TPP, whereas everybody else allowed foreign workers in. So generally the US gives itself special and differential treatment so that it does less than the developing countries in these free trade agreements. And then lastly, this is just a slide with some further information. And so since we were talking about the ratification process and kind of when countries do impact assessments, different countries do it at different stages. So for example, Germany refused to start negotiating a free trade agreement with the US as President Trump wanted because Germany is in a customs union with the European Union, and they said, look, that will break up the customs union. So Kenya, of course, is in a customs union with the East African community. So if Kenya ratifies the UK FTA, that will also disrupt the EAC customs union, and the same for a Kenya-US FTA. And that was grounds for Germany not to negotiate a bilateral free trade agreement. They said it has to be with the EU as a whole. So the equivalent for Kenya would be an EAC-US free trade agreement so that it doesn't disrupt the customs union. The Switzerland, for example, started negotiating US free trade agreement, and at the exploratory talk stage, Switzerland said, look, will you require XYZ on agriculture? The US said, yes, we will insist on that. Switzerland said, look, that's a red line for us, so they didn't continue negotiating. Malaysia started negotiating a US free trade agreement through the Trans-Pacific Partnership Agreement, and they asked the United Nations to do an economic impact assessment early on. That was before they knew the final text and tariff schedules. Then once it was concluded, the Malaysian government commissioned PricewaterhouseCoopers to do an impact assessment and a local think tank, and then other impact assessments on both the TPP and without the US once Trump decided not to ratify it. Found that in the main chapter that Malaysia expected to benefit, the goods chapter, where they thought they could export more, in fact, Malaysia's goods trade balance would worsen. So Malaysia has not ratified that US Free Trade Agreement, now called the CPTPP. So I've given links there at the bottom of that economic impact assessment of the CPTPP and a similar one that was done on the Regional Comprehensive Economic Partnership and who benefits there. Surprisingly, Japan does the best out of that, and almost all the other countries, their goods trade balance worsens. So usually for developing countries, the goods chapter is where they expect to gain, because developing countries are good at making, growing cheap agricultural products or exporting cheap clothing, whereas developed countries usually expect to gain in the intellectual property chapter, government procurement chapter, investment chapter, services, and so on. So if developing countries don't have any benefits from the goods chapter, it's not clear where the benefits are to offset the costs of the other chapters that are usually net negatives for developing countries, like investment, services, government procurement, and so on. So it's not just an economic impact assessment that may be needed. You know, the Kenyan government, for example, might want to look at the impact on its agricultural policies, or its laws, its treaty commitments, for example, under the EAC, and different countries have different ratification processes. So you heard about the Kenyan one. In other countries like Malaysia, it's the executive branch of government that just ratifies at the stroke of a pen, and Parliament is only involved in passing the laws that are needed to implement the free trade agreement. So thank you very much, and I'm happy to answer any questions. I'm sorry that was a bit fast.
Thank you so much, Sonia. I think we've gotten quite a lot from your presentation. And something of interest is how you bring in the summary, and especially bringing out the aspect of Japan being almost the winner in all these agreements. So probably we need to learn more. Maybe we need to have another session with you just to go through what is Japan doing better than all these other countries, so that we can probably get there. So I will welcome now Lydia. Lydia Wairimo Kimani is an agricultural economist with 12 years cumulative experience in agriculture sector. She has recently expanded her horizons to just focus on agriculture and international trades, training in application of the World Trade Organization agreement.
Oh, you are muted.
And she has also a background in agricultural economics and resource management from Moi University, and extensive training on SME competitiveness. She has recently just enrolled and is pursuing an MBA in global business sustainability by the Catholic University of Milan and Tangaza University. She is currently serving as the first vice chair of the African Women in Agribusiness Network, that AWAN. She has served there since 2015 to 2016, representing AWAN in agriculture, devolution planning, gender development sector board at the KEPSA, that's the Kenya Private Sector Alliance. Welcome, Lydia. And for everybody else who has joined us, please kindly feel free to type in your questions. We'll be able to take the questions after Lydia's presentation. Thank you, Lydia. Welcome.
Thank you very much, Nekesa. So mine will be very quick, and mine will just basically be interrogating the presentations we have just had. So from the first one, we realized that there was a rush to get the UK FTA up and running. So we realized that we may not be privy to the contents, yet it has a very significant impact. So maybe this could be some of the things that going forward, SOCA should look into. Are we including as agribusiness advisors the component of public participation, even in processes like treaty ratification, so that we are able to understand that the comprehensive nature in which our constitution provides for the interrogation of the treaties, the binding parts that our country is getting into, and the inherent, are we ensuring that our national interests are safeguarded? So for example, for the UK FTA, those are some of the things we would want to understand. What are some of the submissions and the national interest, the economic impact, especially for agriculture being a contributor to GDP at more than a third, and one of the largest source of employment, especially for rural agriculture. Then the other thing I would be very keen to also interrogate, especially now with the FTAs, and especially implementing them post-pandemic, is the way we are under debt stress, and agriculture is heavily reliant on support from the government, just by the function of extension to begin with. So we realize we have a very our capacity for providing extension service to farmers from a public sector standpoint is very limited. But then you realize that if we continue to surrender our revenues to countries that are way more developed, then we continue to deepen inequalities. We have obligations as member of the United Nations General Assembly in delivering on the Sustainable Development Goals. So are these FTAs perhaps deepening inequalities in our own economy? These are some of the things that we need to also interrogate. For our agriculture sector transformation and growth strategy, in what ways will it be impacted? The ASTGS, for example, cites that majority of the production is done by women. So for us in the agriculture sector as advisors, have we explored the possibility of conducting a gender impact assessment of these FTAs? Are they going to especially affect the revenues that are available to women and support inclusive growth from the agriculture sector? We have also seen cases where the FTAs recommend the removal of export taxes. So export taxes are implemented by governments to promote value addition, a core element as prescribed in our ASTGS. But if we find that export taxes are being clawed back, then we realize that the gains that we are making, the endeavored transformation and competitiveness we seek to achieve in agriculture through value addition, then may just be a pipe dream. So these are some of the things that we need to question. From the presentation also last week, we realized that what are the climate change implications? So as members, as parties to the Conference of Parties of the UN United Nations Framework on Climate Change Convention, we have committed that we are going to contribute 32% in reduction of greenhouse gases. So the agriculture sector is the highest at 43% from the climate smart agriculture. How are these free trade agreements supporting us in the agriculture sector, for example, to build resilience against climate change vulnerability? These are some of the things that even as agribusiness advisors, in what ways are we ensuring that the smallholder farmers are not disadvantaged by the FTAs coming into force and exposing them to even greater climate shocks? Some of the budgetary allocations is actually going into building our resilience for climate change, even in the agriculture sector. When we have that revenue being surrendered in terms of duty-free market access, how are we going to compensate? Again, finally, we have already lost 1 million jobs because of the pandemic. Part of that has also affected the agriculture sector. How do we endeavor, knowing that free trade agreements are actually assigned a 20% reduction of jobs globally? How do we endeavor to circumvent that kind of further loss of jobs? So we need to critically look at this, and as agribusiness advisors, already start seeing some of the ways in which we could just support not just the smallholder farmers, even government, because SOCA is very strong on the advocacy front. As a member of the agriculture sector network, ASNET, and even the Kenya Private Sector Alliance, various sector boards in devolution and in trade. So this should form, this going forward, could this be part of our advocacy processes by ensuring that we are fully interrogating the impact these kinds of treaties are going to have on our end, and especially in delivering a transformative agriculture, delivering jobs, competitiveness, and making sure that we are better off, and especially achieving a green transition, whereby we have reduced waste and increased our ability to even adopt a circular economy, where waste from one particular sector becomes input for the next particular sector. So these are some of my thoughts and on these particular issues, and how going forward, perhaps we need to have an incisive look at the different FTAs now, so that we have a full appreciation of what our country is getting into. And perhaps for the impending US FTA, use the previous examples, the UK FTA, the AFC FTA, the other developing countries' examples and experiences in implementing FTAs to inform a very solidified and well-informed position in terms of getting our government to do right by especially the smallholder farmers. Thank you very much, Nekesa. I submit.
Thank you so much, Lydia, for the lovely summary of the two presentations and just giving us thoughts. Like we need to think through our processes and to think through what we engage in as a country and also as a region, because at the end of the day, we are a strong region. We need to come together and see what benefits us. And maybe just delving into the questions that have been posted. I know Sonia has tried to respond to some of them, but just for the benefit of those who are here, we have a question from Chege and Duta, actually two of them. And one of the questions that she's asking is about the limits that a government can enter into treaties. I guess this is a question for you, Sonia. What provisions are there in terms of the Constitution to ensure here?
Actually, Dennis, I think, because if you're asking about Kenyan law, sorry, my law degree is not from Kenya, so better Dennis answers about Kenyan law.
Okay, we could take both from both your experiences, just to understand in terms of when you're talking about the European law or the English law, how does it apply? I'm sure we also subscribe to the English law. Then we can see the Kenyan context, just in brief. Thank you.
So thank you for
Dennis,
that question.
Yeah.
Yes, thank you for the question. So as I had initially outlined, that a memorandum is usually presented to cabinet when any treaty is signed. And I outlined quite a number of elements, over 11 of them, on the limits that government can enter into. So for example, there was an issue of financial implications. To what extent can we look at the engagement between the parties? Does it affect the constitution? If you remember some of the items I outlined, what are some of the policy and the legislative considerations to look at? So those are some of the thresholds that government will look at before they take the memorandum of the treaty to Parliament for approval. So there are quite a number of items, but government has a yardstick to consider on exactly does it meet the threshold of the Treaty Making and the Ratification Act of 2012. There's a threshold set in the Act.
Okay, just still on to maybe a question from the audience, just tying into that. When you're looking at the ratification, for example, the AFC FTA, we have some countries that have ratified this and some haven't. What does this mean to that kind of agreement? Does it mean it can be enforced? What exactly does that mean?
Enforcement, when all the member states, when all the African leaders met in Kigali to sign the treaty, President Kagame enforced on the element who was then the chairperson of, he was a chairperson of a particular body that involved Africa, but it's not the African Union. He emphasized on the element of unifying the African continent. And the process of implementation of the AFTA is progressive. It is not instantaneous. It is progressive in that member states will have to consider their own local legislations. They will have to consider the ratification process. The regional blocks, COMESA, ECOWAS, EAC, the West African region, they will need to consider on the nature of implementation progressively. What can come first? Because the core pillars of the AFTA are under competition, intellectual property rights, and many more goods and services. What can we commence with? So if one country does not ratify, that does not mean that the AFTA will not be implemented. They will just ensure that there is a common item that has been agreed upon. So the process of ratification is ongoing. There are those who ratified recently, but majority have ratified. But the implementation of the agreement is progressive. It is not implemented instantaneously.
Thank you so much, Dennis. Maybe something you can add, Sonia, especially when it comes to the first question in terms of the treaties that government enter into. Just from your experience, what kind of constitutional provisions are there in the different countries that you've evaluated?
So it does depend on the country, and so some are the legal blocks, but in practice what happens is in a lot of countries you have to change your laws to comply with the free trade agreement, because if you don't then, and you ratify the free trade agreement and it comes into force, you can be sued under the free trade agreement at the International Tribunal, and then when you lose, tariffs can be raised on your exports. So countries have often had to make extensive changes to their laws in order to ratify the treaty, and in some countries the Attorney General's Department is quite careful about making sure that all those changes to laws and regulations are done before the ratification takes place, so that you're not caught out afterwards. And these laws that need to be changed may not just be at the national level, they may also be at the subnational level, like provincial or local government. It may not just be laws, it may be regulations, circulars, directives, guidelines, policies, anything that can conflict with the free trade agreement. And so I was just looking at the AFC FTA, and it seems to say that it comes into force 30 days after the 22nd country has ratified it. So then I guess for those who have ratified it, it comes into force once they reach a minimum number of 22, which I think they've done. And then, as the others ratify, then it comes into force for them.
Thank you for that. And just looking at the different countries, I know you've mentioned about the way the US could subsidize their farmers per year. They allocate about $68,000 per year for their farmers, meaning that the products of those of the US get into other countries who have the bilateral agreements in terms of below the cost of production. That of course implies that the local produced goods then are not really competitive. Is there a way countries can also negotiate in terms of provision for quotas, so that you only import what you require as a country? I mean, this would be part of the negotiation. Is it something that is allowed by such? Can you push for that as a country?
Yeah, so that's a good question, because I mean, if you take it as a given that you cannot make the US reduce their domestic subsidies for agriculture in a free trade agreement, which is what all the other countries have found when they've tried to get the US to cut their subsidies on agriculture in free trade agreements, then what can you do about these products coming in below the cost of production? One is you raise your tariffs so that then by the time they actually reach the marketplace in Kenya, they are, more expensive than the locally produced unsubsidized wheat or dairy or whatever. But if you have to remove your tariffs because of the free trade agreement, or for example because of the World Trade Organization, could you have quotas? And so these tariff rate quotas, actually I do remember seeing a couple in the Trans-Pacific Partnership Agreement. I think Malaysia kept it on cabbage and pork or something like that. So it's reasonably unusual, and I assume it's heavily negotiated, that the US is not just going to let you have quotas on whatever you want and not allow those quotas to be very small. So yes, it's a good idea, you can try, and some countries have managed to get some, but I doubt the US will allow you to have quotas sufficient to negate the removal of tariffs on all of their subsidized agricultural exports.
Maybe just a final question to both Dennis and Sonia. When you're looking at a table of negotiators, as say, for example, the third world countries, the listed third world countries, who would you expect to see? Because we've had a lot of economic impact analysis, gender evaluation. Lydia mentioned that. And I think also, Lydia, you can contribute to this. Who would we want to see on that table of negotiation? And again, on this basis, these free trade agreements, are they a public property? Is it something that you and I, the normal citizen, can actually get access to and comment on and get their inputs into that FTA? So I'll leave this open, and each of you has just to summarize the whole webinar today.
Yeah, that's a good question, and I'm sorry I didn't explain the process. These free trade agreements are usually negotiated behind closed doors, so usually it's only government officials in the room. But some, like the European Union, has been publishing its proposals. I can put a link in the chat to where they have published what they are asking countries to agree to. And then I think in the EU Economic Partnership Agreement negotiations, the EU allowed civil society organizations, say, into the West African delegation in those negotiations. The US typically does not. They are much stricter, only government officials in the room. They do not publish the proposals. The first you see of the text is when the deal is already done. When the negotiation's over, the thing is concluded, it's too late to change, then they publish the text just before it gets to be signed off and then ratified. So that's the standard US way. But there's nothing inherently secret about these things. They don't have to be negotiated in secret. As you could see, with the EU was able to publish them and allow CSOs into the negotiations, and they could still conclude. These same issues when negotiated at the World Trade Organization, whether it's goods or intellectual property or services or e-commerce, the trade facilitation, the negotiating texts are usually published quite regularly, and you can see, you know, there's still square brackets where things are not agreed, and here are the country proposals. So that allows more time for public consultation, informed public consultation, where you actually have an idea what's going on, because otherwise it's hard to give any informed views about the likely impact if you don't know what the proposal is to comment on. And then in terms of who should be at the negotiating table from government officials, the thing is that obviously this is a legally binding treaty. Usually it's highly enforceable. Every comma matters. So it is important to have lawyers in the room, and, you know, ideally a lawyer in every chapter, because often you will negotiate 10 chapters simultaneously on a given day in a negotiating round. So Kenya's delegation needs to have a lawyer in the goods chapter negotiations and the SPS chapter negotiations and the e-commerce negotiations. But the lawyers may not know the substance. You know, they might be from the Attorney General's department, and they might not know the ASTGS agriculture policy. They might not know the economic implications. So often it helps to have a whole team. And so one chapter, for example, the e-commerce chapter, could affect 12, 13, 14 different ministries. So if they're not at the table, then they need to be consulted, you know, after each negotiating round on the proposals in that round. And then don't forget that subnational governments can also be bound by some of these chapters. So they would also need to be consulted if they're not present at the table. Some countries like Canada, I think, would bring their provincial government officials into the negotiations and regularly brief them. In some countries, you have an association of local governments, like a municipal association, and so they may be consulted. But it's quite difficult even for a trade ministry to know all the policies that the other ministries have, and therefore know which chapters to consult them on. And so even when the trade ministry is doing their best, they may forget to consult the Ministry of Health on one of the 12 different chapters that can affect health, or the Ministry of Finance on one of the 21 chapters that can affect the Ministry of Finance. So there's a lot that can fall through the gaps, even in developed countries. So that's one of the things that makes these free trade agreements difficult to negotiate effectively, and to ensure that you don't have unintended consequences and surprising side effects that you didn't think you were agreeing to, but then end up restricting your regulatory and policy space in a ministry or in a subnational government in a way that you didn't expect, and can cause problems then in the ratification process, as you're seeing, say, with the British FTA. Thanks.
Maybe as Dennis, you take this question, you can also add what opportunities are there, seeing that we could get cheaper goods into the country. What opportunities are there as a country? Yeah.
Thank you very much. Let me start off with the members who should be at the table to ensure that the AFTA is well implemented. In my opinion, this is a very good treaty because it makes the ease of doing business come out in a very good way, because African economies would want an environment where the ease of doing business, the cost of doing business is minimized to a level that is affordable by the economies. Yes, we can have the big brains at the negotiating table, but they should also consider the indirect impact and the direct impact of the entire population. Like what was demonstrated recently by the visit of the Tanzanian president to Kenya was just a slice of what the Kenyan economies should do. The tariff barriers, the custom duties at the various border points is just a demonstration of how the ease of doing business should be done between member states. And the East African community is an emerging bloc, because they're in the process of also bringing Congo into the EAC. So there is a strong demonstration of economic empowerment and the ease of doing business between the African countries. Also, the element of intra-African trade is an issue that is coming out clearly, because they might end up unifying or having a standardized tariff, which would be very fatal to an extent, but it is an item to be achieved at a later level. So some of the people I would identify at the negotiating table are the policy makers, people who are well versed with the policies, the heads of the various economic blocks, EAC, COMESA, SADC, and the other regions. Also, it is important to have the legal minds from the various blocks so that they're able to have a legal interpretation of the document. Economically vast minds in the various economic blocks. Yes, basically that would be it. What was the other question again? Hello, Nekesa? Nekesa?
Sorry, I was looking for my mic. There was the opportunities, which I think you've mentioned, and
Yes.
we were looking at who else should be on the table in terms of negotiating for the value of the country. And then maybe, I don't know if you can add anything else, Dennis?
One of the major opportunities that the AFTA is bringing on board is the element of ease of doing business. The element of ease of doing business would mean that I can, for example, if I create very nice vitenges in Kenya, I can easily export them at a favorable price to Ghana, to Egypt, without the necessary tariff barriers at the various border entry points. The EFTA will also harmonize Africa and make it a better continent in terms of having oneness in terms of trade, rather than relying from other continents, although we will still rely on them, but making ourselves interdependent as a continent, because we have very strong resources and also have a better bargaining power with the other economic blocks in the UK, in the US, in China, so that the bargaining power is at a better level. Thank you.
Thank you so much, Dennis. So Lydia, just to sum it up, what opportunities are there? I know we've spoken so much about the impact in terms of what it would do to our economy, but looking at it in terms of flipping the coin, what opportunities are there really in these FTAs? And also, who would you want to see on the table? Minus yourself. Who would you want to see on the table? Lydia.
Oh my goodness.
Lydia, I think we are losing you, or maybe it's my side.
I think Lydia.
Oh, sorry.
Yeah.
I'm sorry. Can you hear me now?
Yes.
Okay, thank you. Apologies for that. So one of the other people that, one of the other stakeholders that I'd like to see, of course, it being a government to government process, I think it's important, and this I have learned in the process of just participating in the advocacy process of the USFTA, to enjoin the private sector. So the practice with the US is to have them as advisors who are on non-disclosure agreements. And the reason why we are saying this is because as policymakers agree on a government-to-government level, it's important to consult with the private sector on the actual impact of the decisions that they are about to commit to. So from an advisory standpoint, I think that is very, very critical. And especially not just have the private sector, but indigenous. Why I specifically say that is because our country is informal. So a lot of the people whose interests need to be safeguarded, and citing just the experience we're having with the UK FTA, are not aware of what is happening. So by the time the impact lands, it's a bit too late. So if we could have that deliberate inclusion, then we would start seeing some of these trade deals working in favor for us. So one of the greatest opportunities is the ability to explore increased market access. And this could be like, I'll give in the case of, for example, in the AfCFTA, we are one of the biggest economies in Africa. So it is interesting that while we may stand at risk with the UK and the US because they are far more developed, we stand to gain because of the size of our economy. But then you find that issues like the cost of production could be compromising us, compromising our ability to fully leverage the advantages. So what I'd advise is that FTAs are different because there are some that will give you lots of latitude and leverage, while others actually shrink that space. But because there are also aspects of this, the notion of increased creation of jobs. So you find that ultimately when you interrogate it, it's a bit, it would actually translate into a positive under the AfCFTA, but into a negative under the UK, US kinds of FTAs. And that is basically because of the level of development. So that's why in the cases of the US and the US and the UK, we would still push for the GSPs, the generalized special systems of preferences, where the agreement is unilateral. For us as developing countries, we have access, but they are not allowed to seek reciprocity. But in the event of reciprocity, then as a developing country, we have very limited chances. So thank you very much. It was a very exciting session. I have learned quite a bit myself also.
Yeah, thank you so much for your final comments, but then just give us a parting shot. Dennis, I'll start with you. Parting shot, just one line in regard to FTAs, and probably in the next session, we could look at the opportunities that Africa has with these FTAs and see how we can flip the coin to of course, be positive on our side. Dennis, parting shot?
Yes, my parting shot would be that this agreement, I would liken it to a boat in the ocean without without an engine. And the participants in the boats are all the 55 countries. So we all need to row the boat and go against every tide that has to happen and ensure the boat does not sink, to ensure that the agreement works out. And I'm wishing the agreement and the team that organized this forum the very best, and thank you for having me as a guest.
Thank you so much, Dennis. Sonia?
Thank you very much. So yes, governments have many policies to balance. They may want cheaper imports for consumers, but then they may also need to think about what happens to their smallholder farmers if subsidized cheap imports come in and the local Kenyan farmers cannot compete with subsidized US wheat or dairy or sorghum or maize and so on. So governments have to manage many different considerations between the needs of exporters to have ease of doing business and the impacts on their climate change and other agricultural policies, gender, informal sectors, smallholder farmers, and so on. And some countries enter these free trade agreements thinking that they will get enforceable new monetary aid or cooperation or assistance through the SME chapter. But when I've looked at the US free trade agreements, all of their cooperation and SME chapters are unenforceable or mere committees. There's nothing useful in them. There's no enforceable aid. And in fact, things that governments want, like technology transfer, is restricted on a negative list basis in US free trade agreements like the USMCA. So you can't require it except in the sectors where they allow you to. So often the perceived benefits aren't necessarily there when you look at the actual text of past US free trade agreements. Thanks.
Thank you, Sonia. Lydia, as we wind up, parting shot.
Okay. Thank you so much, Nekesa. I'd like to just really appreciate what we have been going through. And mine is just to demonstrate to our soccer members and the agriculture fraternity that there is quite a bit to be done, and especially in terms of supporting the sector in terms of trade. So for soccer, my parting shot is that there is quite a bit of linkage to be taken up. because I'm thinking already, if it's for economic impact assessment, this is something that we can do in partnership with academia to support our advocacy positions. And as members of the Kenya Private Sector Alliance and as ASNET, then we can use these positions to further advance our lobby our positions and support them with evidence. So mine is like is that there is need, even for us in SOCA, to stop working in silos. As members of SOCA, we need to break our silos. We've realized the wealth of information that has come from our colleagues from the legal background. Then how much more, as in, if we continue to reach out, imagine the kind of output in a position paper when we're presenting to government. For example, in the US FTA, the kind of quality we present. And finally, that the government has been getting very frustrated because the agriculture sector has not been even participating in the forums. So I believe that is yet another opportunity for SOCA to support the business member organizations in the agriculture space, now that we are building capacity of our members, to cascade this information now to the very grassroots, and it becomes a building block of the ASTG to realize the ASTGS as espoused by government. Thank you very much, and a very lovely night to everyone.
Thank you so much to our presenters today. It was very informative, and we hope that one of these masterclasses will delve deeper into these discussions, maybe picking one FTA at a time that is related to Kenya, EAC, or Africa in general, just to see the implications, the benefits, the negative sides, and evaluate further and see how can we better our future negotiations as a country and as a continent. And I would like to thank again SOCA for this opportunity, and we look forward to discussing more in the next masterclasses. We'll be able to see what role does really agribusiness advisors play in our society, in our community, in bettering our agricultural policy, and especially the implementation. Thank you so much, and have a good evening and good morning for those who are waking up.
Thank you. Bye.
Thank you. Bye. Bye-bye.
Bye.
Bye.
You can say before I.
Bye-bye and good night.
Now
Hi,
that we've
Nikes.
left the three of us, the recording, is it still on? We have to stop the recording.